We're about to start, and it's my great pleasure to welcome you all to the 2012 version of the James L. Lewtas Public Lecture, and especially pleased to be able to welcome both members of the Lewtas family we have here, James's daughters, and also, of course, Joe Arvay, QC, who will be the speaker and give the Lewtas Lecture this year. He will be familiar to, many of you, if you follow Supreme Court case law in the media and elsewhere, but more particularly to members of the student body here at Osgoode. He's already delivered the lecture on the very first day of law school for the class of 2015, and I'm especially pleased to see some members of that class coming back for more, and has already been doing some guest lecturing in classes. He's a visiting professor here at Osgoode as well, particularly providing some mentorship and support to our clinical programs, and he has been singing for his supper all month with more to come, and it's great to join together this program of events for the month of September featuring Joe Arvay and a highlight of every year, which is the Lewtas Lecture. And particularly important at this time in this season, where so much of the focus has been on the Carter-Taylor litigation that is working its way up the courts on physician-assisted suicide, to have Joe Arvay, who is a lead counsel in that case, here to give some reflections on the broader question of a constitutional right to die. So I will not stand between you and Joe for long, but to those who haven't been following his career, haven't seen the very touched up photo in the spread in this current Walrus magazine, in which he's some kind of rock star, and who do want to know a little bit about him, let me just run through a couple of the basics. He has done a little bit of everything, and that includes having been a law professor at the University of Windsor early in his career, working for the Attorney General's office shortly after relocating from Ontario to British Columbia, and of course being on his own and having co-founded, I should say, Arvay Finlay Barristers in 1990 in Vancouver, which has become, over the years, a go-to boutique litigation firm for some of the most compelling and highest profile constitutional cases. But he has had a busy practice in a variety of fields, ranging from labor law to Aboriginal rights, constitutional law, administrative law, medical malpractice, and cases ranging from Cotter to Little Sisters, Conway to the same-sex marriage reference, Okanagan, the health services case that recently established for the first time a constitutional right to collective bargaining, has won a slew of awards, including the Walter Tarnopolsky Human Rights Award in 2000, an award from the BC Civil Liberties Association in 2005, Trial Lawyers Association of BC Award, is a fellow of the Litigation Council of America, is in on everyone's list of whatever the top is, if it's the top 100 lawyers, the top 25. I think we create lists just as an excuse to invite Joe out. Again, his full bio is available on our website, among other places. He did actually go to law school at the university that once was known as the University of Western Ontario. It's become just Western, with a lot of purple. And he did a graduate degree at Harvard, called to the bars of BC and Ontario. And let me just finish on a more personal note. Has been someone who has shown a great willingness as an advocate and as someone who takes a very professional approach to representing clients, also as someone incredibly thoughtful about what he does, thoughtful about the arguments that he advances, thoughtful about the role of the courts, of access to justice, of a client-centered perspective, of what lawyers can do to be problem solvers, not just winning and losing in court, although that's not irrelevant when you're a litigator, and I think represents just the best of what the profession has to offer. So please join me in, again, welcoming Joe Arvay.
Thank you, Lauren, for those very kind remarks. And it's my distinct pleasure to be here today to speak to all of you on the occasion of the Lewtas Lecture. I didn't know Mr. Lewtas, but I understand he was a very highly respected solicitor, a chair of the university's board of governor, a loyal supporter of this school, and he has his daughters here today representing him, and I'm very pleased to present this lecture. I hope it's fitting both of the man and the occasion. I've come to talk to you about whether there's a constitutional right to die in this country. As most of you will know, that the Supreme Court of Canada in the Rodriguez case in 1994 said that there was not. But most of you will also know that this past July, the British Columbia Supreme Court in the Carter case came to the opposite conclusion, and we expect, of course, that that decision will be, well, it is being appealed, and we expect it'll go all the way to the Supreme Court of Canada. I wondered about the utility of giving this talk on an issue, on the issue given that there's a decision, a decision that you can all read and learn just about everything and more than I could give you in this lecture. So I asked, well, what could I add that would be useful? I suppose I might perform a somewhat useful function if all I was to do was to summarize the decision of the BC Supreme Court, since it's almost 400 pages in length, and I doubt that many of you have read the decision or ever will. And so in the briefest possible way, I'm going to just tell you what the essence of the decision is. The BC Supreme Court held that the laws of Canada that absolutely prohibit any kind of physician-assisted dying violate the rights of Canadians to life, liberty, and security of the person, and also violate the rights of the physically disabled to equality under the Charter, and that those violations were not justified under Section 1. The court struck down the law and told Parliament that it had 1 year to draft a law that allowed for physician-assisted dying, albeit in very carefully circumscribed circumstances and subject to rigorous requirements. Well, the court did not specify all of the details of what that legislation should contain. The court did make it clear that physician-assisted dying must be available, and I'm going to just read you the requirements. Must be available to a fully informed, non-ambivalent, competent adult who is free from coercion and undue influence, who is not clinically depressed, who personally and not through a substituted decision maker requests physician-assisted death, and who has been diagnosed by a medical practitioner as having a serious illness, disease, or disability, including a disability arising through traumatic injury, is in a state of advanced weakening capacities with no chance of improvement, has an illness that is without remedy as determined by reference to treatment options acceptable to the person, and has an illness causing enduring physical or psychological suffering that is intolerable to that person and cannot be alleviated by any medical treatment acceptable to that person. Now, you can appreciate that just about every one of those words begs 100 questions. And I don't have the time to address really any of them. But it obviously, those conditions underline just the complexity of the issue that was before the court. So that pretty well summarizes the ruling or order in that decision, so you don't have to read the 400 pages now. But I'm actually not here to talk about much law, notwithstanding that this is a law school lecture, and probably most of you in the room are law students or law professors. The main reason that I don't come here to talk about law is that I don't actually think the outcome of this case will depend much on law, shocking as that may sound, but rather on the facts and the policy issues that lurk beneath the surface of the case. And so those sort of policy issues that I really want to address my remarks. Those who oppose physician-assisted dying rely on a number of arguments. Let me start with the sanctity of life or inviolability of life argument. Of course, everyone is in favor of life, but the sanctity of life argument cannot be taken too seriously if it's presented as an absolute value. Indeed, the Supreme Court of Canada in Rodriguez admitted as much when it acknowledged that some kinds of assistance in death is indeed legal. The court was referring to what it calls passive euthanasia, a rather compendious term, which described such end-of-life measures such as the withholding or withdrawing of life-sustaining treatment, whether it's ventilation or dialysis or medication, or even in some circumstances the intentional killing by a doctor, intentional killing by a physician. One notable example was with respect to a boy in England who was in a persistent vegetative state, and the House of Lords said that at the request of the family, the physician could withdraw any kind of food or nutrition or hydration, and that was acceptable because it was killing by omission rather than by commission. The Supreme Court of Canada in Rodriguez accepted the validity of that distinction, maintaining the point that passive euthanasia, the distinction between passive euthanasia and active euthanasia, was not only legal, but was moral or ethical. Indeed, the court said that to cross that line from passive euthanasia to active euthanasia was to cross the Rubicon itself. Well, we wanted the court to make that crossing. And this gave us the opening to do what I don't think has ever been done in a Canadian courtroom before, and that was to call the opinion of philosophers and ethicists. And foremost among those experts was the University of Toronto Professor Emeritus Wayne Summer, whom I'm actually happy to see is here with us today. Professor Summer persuaded the trial judge that there was simply no ethical distinction between the various and common end-of-life measures that come within the term passive euthanasia and the active euthanasia that we were seeking was in some circumstances to be constitutionally required. Indeed, he persuaded the trial court that there was no ethical distinction between suicide itself and assisted suicide. Now, we appreciated that what is or is not ethical cannot determine what is or is not constitutional. But to the extent that the Rodriguez case rested on there being an ethical or moral distinction between what the court called passive and active euthanasia, and indeed suicide and assisted suicide, we demolished those distinctions. Now, there is, of course, another side to the sanctity of life coin, and it is the one that we emphasized. The court heard the evidence of many persons who said that the present law might cause them to take their own lives sooner than they otherwise would want to, because if they waited until their life was truly unbearable, they would be physically incapable of committing suicide. And to wait that long and ask for assistance from their family or friends would place their loved ones at risk of criminal prosecution. So they were faced with the horrible and Hobson's choice of either a premature death or an agonizing life. The evidence allowed us to argue that the law, which apparently had as objective the preservation of life, actually deprived some people of their life, which was guaranteed by Section 7 of the Charter. And this was hardly a theoretical concern. One of our witnesses was a wonderful man by the name of Nagy Morkos. He was suffering from Huntington's disease, and a few months after the trial, but before the judgment came out, he ended his life by suicide. And he did so well before he was ready to die. This is a note. This is what he said in a note left for his family. In deciding on the timing for hastening my death and to stay within the current laws, I had to do this myself and couldn't get any help. It was a precarious balance between doing it too early and missing out on my rich life and doing it too late when I was no longer capable. Now, with the sanctity of life argument behind us, we had to tackle the dreaded slippery slope. And this is where much of the government's argument was directed. I have to tell you first, though, that there are apparently many kinds of slippery slopes, two of which are the practical slippery slope and the logical slippery slope. The practical slippery slope is premised on the idea that even if there is a law that allows physician-assisted dying for people who should have it, let's call them non-vulnerable people, that nevertheless, because of the infallibility or perhaps even the malevolence of people who have to administer the law, some vulnerable people will be have their death hastened. This doesn't actually seem to me to be a slippery slope as much as an even plane where people fall through the cracks by virtue either of mistake or perhaps even abuse. But anyway, that's called the practical slippery slope. And through those cracks will fall those who, for instance, may not be fully competent, who may not be exercising a truly voluntary choice, who may not be fully informed. I'll come back to the practical slippery slope in a minute. The logical slippery slope is apparently based on the idea that if the law allows one group of people, let's call them fully competent adults who are suffering, to avail themselves of physician-assisted dying, it is only a matter of time that the law will allow another group of people, let's call them incompetent adults, who are suffering intolerably, to take advantage of physician-assisted dying. Now, I don't actually understand why that's logical at all, but those who oppose physician-assisted dying seem to think it is. But I think I can answer this claim fairly easily. In the first place, to the extent that it is a claim that we are on the road to the kind of involuntary euthanasia practiced by the Nazis in Germany, it is pure fear-mongering and should be treated with the ridicule it deserves. But to the extent that it assumes that Parliament one day in its wisdom might determine that the law of physician-assisted dying should be extended somewhat beyond that required by the Constitution, for instance, so that it may be available to a person who is incompetent today but who had left an advance directive when they were fully competent, then isn't that democratic expression of the public good exactly what the present opponents of physician-assisted dying say is presently lacking? How could it be something that they could complain about? And thirdly, if the extension it comes not from Parliament but from the courts in future cases because it's required by the Constitution, which is supposed to reflect our fundamental values, ethics, and morals, then how is that any different from what happened in the progression of the jurisprudence in the area of, say, gay and lesbian rights, which proceeded from protecting gay and lesbians and transgendered people from acts of discrimination to eventually celebrating same-sex marriage? Now, it was the practical slippery slope, though, that was likely the main reason why Sue Rodriguez lost her case, because the Supreme Court of Canada said there was simply no halfway measure, halfway between an absolute prohibition on the one hand and complete decriminalization that could be relied upon with assurance to protect the vulnerable from seeking assisted death in times of weakness as compared to those who genuinely desire it because they are, for instance, terminally ill. And those are the court's words. Now, of course, the singularly important area of evidence that we were able to call that was not available to the Supreme Court of Canada in the Rodriguez case was the evidence from those jurisdictions where physician-assisted dying has been legalized in one way or the other. This would have been Netherlands, Belgium, Luxembourg, Oregon, Washington, and Montana. There was truly a remarkable and impressive amount of evidence from the social scientists and physicians who had intensely studied the operation of those regimes, and in particular the extent to which physician-assisted dying was being practiced, the demographics of the patients who would avail themselves of it, and the nature and extent of compliance or non-compliance with the requirements of the law. And as to the risk of wrongful deaths, in other words, meaning deaths to persons who may not be competent, whose request for death may not be truly voluntary, whose wish was not based on full information, and the risk that the elderly and the disabled are more at risk than other segments of the population, the trial judge said, for sure there are those risks. But she went on to say that they can, quote, be identified and very substantially minimized through a carefully designed system imposing stringent limits that are scrupulously monitored and enforced, end of quote. Now, these are her findings of fact that, in my view, are unassailable, and the higher courts are very unlikely to interfere with them. The Crown and its allies will have to find a different path if it is to seek to reverse the decision of the trial judge. I'm sure I'm not going to be helping the Crown when I imagine that one of their grounds of appeal will be that very substantially minimizing the risk is not good enough. Indeed, it was argued before the trial judge, and will no doubt be continued to be argued in the higher courts, that the only way the court could, as a matter of constitutional law, strike down the existing laws, if the court was satisfied on the evidence that with any new law which had legalized physician-assisted dying, there would not be one person ever who would be wrongfully assisted with their death. In other words, it was their zero tolerance argument. We got into an interesting debate about the apparent contradiction between our very Canadian abhorrence to capital punishment and our support of physician-assisted dying. The Crown's mantra, a recent one by the way, was that just as it was wrong for even one innocent person to be executed by the state, that it is wrong for even one person to be wrongly assisted in their death by a doctor. The analogy, in our view, was completely inapt. No one on death row wants to die. Being executed is being killed against one's wishes. What we were advocating was the totally voluntary and persistent wish for assistance in death by a fully competent person. Now, I appreciate that the question of the competence and voluntariness of a requester might be an issue, but context is everything. And the trial judge, while actually being initially attracted to the Crown's argument, ultimately rejected it because she said there's simply more risk of wrongful death in the face of persons who both dispute their guilt and express a wish to live than there is in the context of a grievously ill person who may already be close to death from seeking medical assistance and dying when they seek to do so. We also said that to accept this zero tolerance approach would be to effectively immunize the law from charter scrutiny. To that, the Crown said, so be it. The Crown said it is one thing as a matter of policy for Parliament to enact a law that allows for some risk of wrongful death. It is another thing, the Crown said, for the court to require Parliament to enact a law that allows or even makes inevitable some wrongful deaths, because we conceded that no matter how careful and detailed the law and its enforcement, no one could guarantee that no one would ever slip through the cracks. This zero tolerance approach has never governed the medical profession, nor for that matter the legislatures or colleges that govern their behavior, nor could it be, as it would paralyze the very practice of medicine. As some proof, we pointed out that the legislatures and regulators across the land expressly condone that which goes on every day in every hospital in every critical care unit in the country. And again, I refer to those legal decisions by which doctors withdraw and withhold life-sustaining care with the certainty and knowledge that this will kill the patient. And it needs to be emphasized that there exists the very same risks of wrongful death in that context. In other words, as there would be in a regime of physician-assisted dying. In other words, requests from persons who are incompetent, requests that were not truly voluntary, requests based on inadequate information. Indeed, the risk of wrongful deaths today in the ICUs across the land are even greater than would be in a regime of legalized physician-assisted dying, because there are no laws or regulations that govern any kind of end-of-life measures in those hospitals. But saying that because wrongful deaths may already be occurring in critical care units may not be a particularly compelling counterpoint, as we all know that two wrongs don't make a right. But the fact is, and the trial judge found, that given the medical profession's extensive familiarity with the doctrine of informed consent, very few such mistakes or wrongs do occur in those end-of-life situations, and there's no reason to think they would be committed if physician-assisted dying was legal and highly regulated. There was some evidence not just of mistakes, but arguably of abuse and deliberate flouting of the law in the Netherlands and Belgium, both in terms of euthanizing people who didn't explicitly request it, and that's the legal requirement in those countries, an explicit request, and also poor reporting. I don't have the time to take you through the evidence or even the judge's findings, except to tell you this, that the evidence was that there appeared to be considerably less abuse after euthanasia was legalized in those countries than before, that there was greater abuse of euthanasia in countries that didn't have legal physician-assisted dying than in countries that did. And most importantly, one cannot assume that if physician-assisted dying was legalized in Canada, that anything similar would occur in Canada. And this is because the trial judge found that before physician-assisted dying was legalized in the Netherlands, it was being practiced anyway and being practiced by physicians, and with a relative degree of impunity. The culture there seemed to be one where doctors were somewhat above the law. Hence, it might explain why, even after legalization, some doctors at least carried on in an unlawful fashion, not expecting much to happen to them. But that culture has never existed in Canada, or according to Canada's own witness, the United States. Well, there's clearly some unlawful assisted dying happening in Canada, and I'm going to talk about that in a moment. The trial judge found that there was no comparable history of such prevalence of physician-assisted dying in Canada, and hence it would be wrong to assume that if physician-assisted dying was actually legalized in Canada, there would be any deliberate noncompliance or abuse with the new law. A more fundamental point remains: zero tolerance to the risk of harm is simply incompatible with the Charter exercise. We simply cannot deny to those whose suffering is both horrific and certain their charter rights to die with dignity because of the very speculative risk that someone else who shouldn't die might. All that the law can ever do is devise as many safeguards as possible to eliminate the risk. Indeed, the very essence of the Charter exercise is to balance the deleterious effects of the law against its salutary effects, and the balancing can never require zero tolerance to the risk of harm to third persons when someone's charter rights are so otherwise so certainly and so seriously violated. To allow otherwise would be cruel, plain and simple. The law had many deleterious effects. The approach that we took in this case was not just about one person, even though Gloria Taylor was obviously carrying the torch left by Sue Rodriguez. We presented the court with the evidence of many people from across Canada and indeed the world to demonstrate the hardship and suffering that the law was causing and perpetuating. The court heard sad and brave stories from men and women suffering from ALS, Huntington's, Parkinson's, MS, various forms of cancers and strokes. One particular kind of stroke left people in the aptly named locked-in syndrome, where the only thing the person could do was blink. Here's an excerpt from the affidavit of one of our witnesses, a man by the name of Tony Nicholson, who had locked-in syndrome. And this was an affidavit that he provided to me by blinking. He says, "I am a 56-year-old man who suffered a catastrophic stroke in June of 2005 while on a business trip to Athens, Greece. It left me paralyzed below the neck and unable to speak. I need help in almost every aspect of my life. I cannot scratch if I itch. I cannot pick my nose if it is blocked. And I can only eat if I'm fed like a baby, only I won't grow out of it, unlike the baby. I have no privacy or dignity left. I am washed, dressed, and put to bed by carers who are, after all, still strangers. You try defecating to order while suspended in a sling over a commode and see how you get on. I am fed up with my life and don't want to spend the next 20 years or so like this." Tony started his own case in England, and the High Court in Britain on August 16th dismissed his challenge. A week later, he took his own life by suicide. He took his own life by starving himself to death. And I recall the moment in the court where in my court where the lawyer for the provincial government argued that the disabled like Tony are not discriminated against because they, like able people, can commit suicide. The only difference is that the Tonys of the world are limited to starving themselves to death. This prompted the trial judge to ask whether this might not be a bit cruel. If any of you have ever watched the movie Hunger, about the hunger strike engaged in by the IRA prisoners in Ireland, you'll appreciate how terribly gruesome dying by starvation is. The lawyer then said that the doctors could help by administering a medication that would somehow relieve the agony of the starvation, the agony of the starvation. The lawyer seemed completely oblivious to the implications of what he said. How was that not physician-assisted dying? The trial judge set out in some detail the account of one of our witnesses who had anal cancer, who talked about her, quote, oozing putrescence and mucus and blood and fecal matter out of every orifice. The Crown characterized this and other evidence as our blood and excrement evidence, designed to sway the court by appeal to sympathy rather than by reason. To some extent, we pled guilty to that charge. We believed that the court needed to hear the real stories of real people, that what the Crown wanted to do was sanitize the case and have it be an abstract debate by experts and statisticians and the like. The stories the court heard were indeed at times gruesome, because for some people, dying is gruesome. But what the court also heard were stories of amazingly strong and independent people, people who live vibrant and wonderful lives. Because what became obvious to all of us is that the people who are most likely to want to avail themselves of physician-assisted dying are not people who are weak or vulnerable or fragile, as persons like Margaret Somerville claims, persons who fear about being abandoned, but in fact strong people, people who are much loved and supported by their families, people who want to die as they have lived, to die in a way that does not undermine the way that they have lived. Gloria Taylor was this kind of person, as was Nagy, as were many other witnesses and their family members who testified in the trial. I'm going to take the time to read to you an excerpt from the wife of one such person who had ALS and wanted physician-assisted dying. These are Nika's words, and it's about her husband, Robert. To understand Robert's position and life-ending journey, one needs to know something about him, his personality, likes and dislikes, a potted characterization of him, because a man is someone, not a cipher. He was a brilliantly intelligent and intellectual Renaissance man, equally at home in the arts and sciences, a potter, a sculptor, a chef, marine scientist, science researcher. His first degree was philosophy, his master's degree in oceanography. He spoke 6 languages. Robert was a great raconteur with wit, always building the tension of his stories until the denouement broke us down in tears of laughter. He was a prawn farming specialist, a fisheries author, a seaweed researcher, a teacher, above all a communicator. A person unable to walk down the street without giving you a treatise on the flora, fauna, architecture, and history of the area. If any one of our children developed a fifth of his knowledge, they would be educated indeed. He was always looking to learn something new, never hesitant at trying to develop a new skill, though some things failed him, like playing the saxophone or singing in the choir. He believed a day of living was wasted if he didn't learn something new or teach something new to know another. Robert told me, and I believe that for him, life was more than just breathing or existing. Life was learning, doing, being involved. Above all, living was about communicating. He loved solitude and quiet that allowed him to read, learn, and think, but he loved company, to teach, to share humor, to share knowledge. He knew his illness would leave him incommunicado, but still breathing, trapped in a paralyzed body, a living hell, a nightmare. Worse, this nightmare of extended dying would have no raison d'etre to him. He told me he felt that there was no value to a life of mere existence, merely breathing, not to him nor to anyone. He told me that he believed that for others it would only oppose a burden, even if it were one they were willing to bear. For himself, it achieved nothing. He had no religious belief that dictated it was good to suffer. He had no hope of remission, improvement, or delay, just the inexorable decline into full silent paralysis. Not even able to complain or to praise, a daily grind of being attended to, unable to communicate or to do anything, unable to give. Robert died in his home surrounded by his family after his family prepared him a dish of curry. He actually wrote in his notebook just before he died, "Curry to die for." And after taking a few mouthfuls, he raised his fist in a feeble power salute and then gently passed away. His wife, Nika, said that Robert died almost as he wished. He had a good death, but he told her that he was distressed that he had to go outside the law, worrying if his family might suffer the consequences of that. But the Crown said if physician-assisted dying was allowed, it can be used by people not so strong or supported as Robert and Nagy and Gloria Taylor. Indeed, where the case became the most challenging for me was with respect to the argument that was mounted by the disabled rights organizations, which intervened and which opposed any kind of legalization of physician-assisted dying. In an article in the Globe and Mail a few months ago, Justice Major, who was in the majority in Rodriguez, was reported to have said that what he remembers most vividly about the hearing was the silent ranks of disabled people, their wheelchairs ringing as the courtroom full of lawyers debated the law. He said for this reason it was a haunting type of case. Well, here is where the case got not just challenging for me, but personal, and more personal than I would have realized when I started the case. And you will all appreciate the rather obvious reason. In our courtroom, the legal debate might have been better described as the verbal equivalent of wheelchair murder ball. I will try to set out as fairly and respectfully as I can the view of the disabled organizations advance, and then provide you with my response. The view of the main disabled organizations in Canada, which the federal and provincial governments adopted, was based on what has been called the social model of disability. That model claims that while people may have impairments based on illness or trauma, it is society that really disables them. Simply put, I may not be able to walk. My ability to walk is impaired by my spinal cord injury, but it is a society that allows buildings to be constructed with stairs that disables me. Of course, the prejudice and discrimination that disabled people face runs much deeper than a city of stairs. As a disabled man, I know full well and have experienced and continue to experience prejudice and stereotyping. That usually manifests itself not so much in hatred or ridicule, although that can happen, but rather in pity. And that pity, in turn, can manifest itself into the insidious idea that one may be better off dead than disabled. The disabled organizations are concerned that if physician-assisted dying is legalized, that it will be based on that very premise, that the state will be endorsing the message that if, for example, your mobility is so impaired, if you require a machine to breathe, if you are so dependent on others for your care, for your feeding, for your dressing, for your toileting, that you must be better off dead. That being paralyzed from the neck down and not being able to enjoy the feeling of human touch or any kind of sexual or physical pleasure is in fact the equivalent of being dead. The concern of these organizations is that if physician-assisted dying is legalized, that message will not only be accepted by the public, but will carry into the doctor's office. And for the disabled patient, as compared to, say, the patient with cancer, the doctor will be too quick to suggest death rather than rehabilitation or palliative care. And the message will not just be one the doctor believes, but that it will be one that will be internalized by the disabled themselves, so that they will consciously or unconsciously come to accept that they should just kill themselves. And since the most common reason many people say they want the right to die is not physical pain, but the prospect of living a life dependent on caregivers for the most intimate details of one's life, the disabled organizations turn this around and say to give effect to this reason is itself an act of discrimination. They say it is ableist societies imposing its view on what it considers to be a dignified life. It is not the view of the disabled person who says that this is simply what I need to do to get up in the morning and get on with my day. Indeed, the evidence called by the government was of such very severely disabled persons who said that at a certain point in their lives, when first disabled, they really did want to die. And had physician-assisted dying been available, they would have availed themselves of it. But having been denied that option because it was illegal, they persevered, and notwithstanding their most severe disability, went on to live rewarding and happy lives, and were very relieved that they had not killed themselves. Well, that kind of evidence prompted a number of different responses from me. The first was that the court could not reject the idea of physician-assisted dying because of the wholly hypothetical, if not metaphysical, notion that if the person had not chosen death, they might have chosen life. At some point, we have to allow people to make their own calculus of the risks and benefits of living, because if we refuse to do so, we condemn some people to a life that will turn out to be one of only misery and suffering. The second was to turn this argument on its head. The evidence did reveal that almost everyone who is first seriously disabled, usually by car accidents or diving or sports accidents, say they want to die. I was no different. But the amazing nature of being human seems to be the virtually indestructible will to live, to rise above and conquer the most devastating injuries. Superman, also known as Christopher Reeve, when as a result of falling off his horse in the prime of his life and became a quadriplegic, went from being society's supreme specimen of masculinity and virility to the disabled organization's supreme example of living a dignified life. Stephen Hawking is still the poster person for that life. These and many, many less famous disabled persons provide inspiration and proof that being disabled is no reason to want to die or to be better off dead. but it was also proof, to some extent at least, of how exaggerated was the suggestion of the disabled organizations that legalization of physician-assisted dying would cause a rush of disabled persons heading to the doctor's office for a lethal prescription. So it seemed to me, rather than maintaining the existing and absolute criminal prohibition of any kind of physician-assisted dying, Parliament might, in legalizing physician-assisted dying, impose as one requirement that there be a significant waiting period before any newly disabled person, especially one who is relatively young, was allowed the option of assisted death. And by significant, I mean a matter of 1, 2, possibly 3 years, rather than the period of months or weeks that might be allowed for a person with a degenerative illness like ALS. And the trial judge indeed imposes a requirement that the person be in a state of advanced weakening capacities with no chance of improvement. That is rarely the case of a person disabled by accident or trauma. Indeed, what we must do before any disabled person opts for a physician-assisted dying, but indeed any person, is to make every effort to counsel that person against it. This must not only be a voluntary decision, but one of last resort. But this was still not seen as a solution by the disabled organizations. They were very critical of cases like Outen, where the Supreme Court of Canada refused to recognize the right of autistic children to have government funding for their treatment. They criticized the refusal of the courts to use the Charter to impose positive obligations on the state to provide all people with the basic human right to housing and welfare and health care and education. They said we need to have a society of laws in which there is dignity in living before we talk about laws that ensure dignity in dying. That if we had such a society, they say, no one would want or need anything like physician-assisted dying. Well, what I considered to be the height of hypocrisy was for the government to endorse that plea, to get on that bandwagon, to argue that the disabled should be denied the choice of physician-assisted dying when the government has within its power to change or enact laws and policies that will help the disabled to live a life with dignity. And while I agree with the disabled organization's criticism of the existing jurisprudence, I don't accept that no disabled person would ever not want or need physician-assisted dying just because there were better social and economic supports for the disabled. Rather, we would be in the better position to assume that the disabled would not want it for the wrong reasons. But we can guard against that possibility by some of the requirements I mentioned above. Without dying, all disabled that choice. It's also important to know that the studies in Europe and the United States where physician-assisted dying is legal, there was no evidence that the disabled are at heightened risk of being killed, and the trial judge so found. But most importantly, the fact is that for some severely disabled people, being disabled is not a societal construct, but it's the reality of living with a very serious and irremediable and very real medical condition that for some is simply intolerable. And if that means that one is somehow being co-opted into believing in some ableist society's views of what is an undignified life, well, this is the society we live in. And it would be wrong and arrogant to characterize a request for death in that circumstance as irrational, a point the trial judge understood and I believe accepted. There must come a point in time when we must be able to respect the decision of those competent disabled persons who have made a voluntary decision to die and but for their disability are not able to do it without assistance. To refuse to legalize physician-assisted dying because of the assumption that all disabled persons are at any and every point in time in their lives too vulnerable, too fragile, too brainwashed by ableist society to resist the suggestion of doctors or family members or societies as a whole that they are better off dead is patronizing and indeed infantilizing. As one of our experts opined, any such assumption feeds rather than starves discriminatory attitudes. I see the time, and I wanted to spend some time talking about palliative care, but I think I'll leave that in if there are questions about it. I'll just end by saying this, that I've talked a lot about what Canada might look like if physician-assisted dying was legalized. But I want to talk about the Canada that we lived in where it is a crime. The plain fact is that assisted suicide and even euthanasia is happening in Canada, but it's happening in what might be described as the proverbial back alleys, the same back alleys where abortion was taking place before it was decriminalized. Back alleys where ineffective drugs are smuggled in from Asia and Mexico, where people have to go out and buy helium tanks and plastic turkey bags that they then turn into macabre killing machines that often fail and leave the patient alive, but now with brain damage in addition to their pre-existing illness. In this connection, the comments of Professor Emily Jackson are noteworthy. She says, of course, the fact that something bad happens outside of the law is not a good reason for legalizing it. Rather, my point is that given that illegality leads to worse assisted deaths than would happen under restricted conditions of legality, if we think assisted dying is sometimes justifiable, then it is regulated assisted dying which should be preferred. In the end, the government's vigorous defense of our challenge seemed to resort to a rather hyperbolic claim, always cloaked in the metaphor of the very slippery slope, that if we were to legalize physician-assisted dying, we would go from a country in which doctors committed to the healing of their patients would become trigger-happy. This is implausible in the extreme. And there will always remain two very important reasons that physician-assisted dying will be a relatively uncommon occurrence in Canada, just as it is in all the states and countries where it is allowed. The first is the irrepressible will to live that we all have. The second is the extreme reluctance of doctors to take the final step in assisting a patient to die. And one of the reasons that we have advocated a system of physician-assisted dying and not one where anyone can assist, is precisely because that this is not only a health issue, but having doctors as the gatekeepers will ensure that it is only resorted to as a last resort measure. And doctors have all the expertise needed to best ensure that any decision reflects one's free will and competence, since that's what informed consent is all about. Yet it would be a mistake to think that those who this case will benefit is only a tiny minority of the population who would avail themselves of physician-assisted dying. Indeed, it was the Crown's argument that given the very small number of people for whom this would be a legitimate option, that needs to be balanced against the risk of wrongful death to too many others, and that the balance, the Crown argued, would tip in favor of those others. And I said this is a false dichotomy. In the first place, tiny is a relative concept. In the Netherlands, it's about 1.9% of all deaths. If this was to be extrapolated to Canada, then in absolute terms, it would be about 5,000 people. That's a lot of suffering to be avoided if physician-assisted dying was to be legalized. But even if we accept that this is a tiny number in relative terms, it doesn't tell the whole story. The evidence in places like Oregon is that a very large percentage of persons who have been given prescriptions for a lethal medication never use them. Indeed, there are as many as 9 times the number of people in the Netherlands who make serious inquiries about physician-assisted dying than ever go through with it. But what these prescriptions provide, and what a regime that allows the possibility of physician-assisted dying provides, is peace of mind. The peace of mind that should life become intolerable, that there is a peaceful and dignified way out. And it is not suicide with all the tragic implications of that for the patient and his or her family. But the peace of mind that when the time comes to end one's life, there will be a kind and caring doctor who will be there to assist. This is the ultimate palliative. It is what a society committed to the values of autonomy and mercy should provide. And this is why the case is for all Canadians, not just the tiny few who will act on it. It's for all of our moms, our dads, family and friends, indeed for all of us who, as we age and face the possibility of untimely and intolerable suffering, will have the right to die with dignity. Thank you.